Hi, bankruptcy attorney Brian Barboza here, and today I'm going to discuss if you file for bankruptcy, will your car loan company allow you to keep your vehicle? Before we get started, if bankruptcy is something that you want to talk about or want to explore, please feel free to give me a call or go to my website, barbozalaw.com. You can book an appointment to speak with me for free directly through the website. All right, so if you were to file bankruptcy, would your car loan company allow you to keep your vehicle? So first of all, let me preface this by saying I'm a California licensed attorney, and although bankruptcy is a federal matter, this particular issue and what I'm about to talk about is specifically geared towards individuals who are in California and who will be filing bankruptcy in California. All right, now with that disclaimer out there, let's talk about it. So when you file for bankruptcy, and you have a loan, like a car loan, that is what we call a secured creditor. That secured creditor, as most people understand, is if you don't make your payments, the car loan company will come and take your car. Now, if you file for bankruptcy, their lien against your vehicle is going to remain on the vehicle. So, of course, you still have to make your car loan payments, okay? But the question becomes, by filing bankruptcy, is that going to somehow cause your car loan company to repossess your vehicle? And so let's go back to the history of this issue. A long time ago, it used to be what we would call retain and pay. When you filed a bankruptcy case, as long as you were still making your payments and you continued to make your payments, you could retain the vehicle, continue to pay, and your car loan company would not have been able to take the vehicle from you. However, the court's interpretation of that rule changed numerous years ago, and the court decided, or the bankruptcy court, in interpreting certain laws, said, you know what? If the lender, or if the borrower, the person who's filing bankruptcy, does not reaffirm the car loan, then the car loan company would be well within their rights to come and repossess the car, even if the bankruptcy debtor, the borrower, was current on their payments. And this was because under car loan agreements and contracts, filing for bankruptcy is deemed to be a material breach of the contract. It could result in an acceleration of the payment, meaning all payments are due, and or it's just a breach. And therefore, the court's interpretation is, you know what, if the debtor does not reaffirm the loan, then the car loan company could come and take the vehicle. Now, reaffirming a car loan means you're going to sign an agreement with the lender during the bankruptcy case that you're going to still be completely personally liable for the debt in exchange for the fact that they will not come and take the car so long as you're making your payments. And this agreement had to be approved by the bankruptcy court judge. However, so that basically ended the whole retain and pay dynamic. However, recently, I think September 28th, 2022, the state of California has signed into law that if in California, if a debtor if a person who has borrowed against taken a car loan out, if they file for bankruptcy, that is not going to be deemed a breach of the agreement, and the lender would not be allowed to repossess the vehicle simply because the person filed a bankruptcy case. So as long as the person continues to make their payments on time, they can file bankruptcy in California, they can keep their vehicle, and they do not have to reaffirm the debt. So basically what California did is they, what we call codified, the whole old retain and pay dynamic. So now they have made it a law that is so long as you keep making your car loan payments, even if you file for bankruptcy, you don't need to reaffirm the debt. Just keep making your payments on time, and the lender would not be allowed to repossess the vehicle merely because you filed for bankruptcy, which is wonderful because I was never a big proponent of reaffirming car loans. Most of the time when I have clients, they're already struggling to pay their bills and then having to prove to the judge that you can also make sure that you still pay your car loan, and in the event you don't pay your car loan, they can sue you, or what if the car breaks down or you get in a car accident and you're still liable for the debt. So I was never a big proponent of reaffirmation agreements anyways. So this is good news for debtors. I'm happy to be able to report this news to anyone who's considering filing bankruptcy in California. So again, if bankruptcy is something you are considering or want to talk more about, please feel free to give me a call or go to my website, barbozalaw.com. Book an appointment to speak with me for free directly through my website. As always, thank you for taking the time to watch this video. I hope you got something out of it, and have a great rest of your day. All right, take care. Bye.